Okay, welcome to our webinar today, focusing on understanding the basics of statutory protections for agricultural operations in Pennsylvania. This webinar is part of our Understanding Agricultural Law webinar series. And this webinar series is focused on attorneys and other business advisors that are representing agricultural clients, but not necessarily attorneys and advisors that are exclusively focusing their practices on agricultural clients. And so our goal with these webinars is to provide focus on a particular topic, provide the basics so that you can understand kind of the basic, have a basic literacy on that particular topic. Now, as we move further into this webinar series, we are going to start to hit some topics at more of an intermediate or an advanced level. But at the as we work through the early part of this series, we have been focusing on topics at an introductory or a basic level. Now this webinar series, we are working with the Pennsylvania Department of Agriculture's Agricultural Business Development Center, which is an entity that was established as part of the 2019 Pennsylvania Farm Bill and is focused on assisting agricultural operations with a variety of or in a variety of different business aspects. This is the fourth webinar in this series. You can see the first three webinars. The first one we focused on ag labor laws, then we focused on leasing farmland for energy development, and last month we focused on local land use regulation. If you were not able to participate in those webinars, go to our website and you can watch the webinar from our website. Now, the webinar for today is somewhat of a follow-up of the last month's webinar on local land use. The topics that we're going to cover today, or the statutes that we're going to address today, kind of touch on a lot of the local land use issues, but they are really their own, I think, their own standalone topic, and we thought it was best to kind of separate those these four statutes that primarily the four statutes that we're going to talk about today as really being kind of, I look at them as really the four core statutes that deal with ag operations. Now, looking forward, and I think this is the first time we've released these topics, but moving forward over the next 3 months, the topics in this series, the webinar series, next month we're going to address agricultural cooperatives. September, we're going to address livestock market regulation. So we'll talk about the Packers and Stockyards Act, and we'll talk about some antitrust issues that have been, which has been a big topic recently. And then in October, we will talk about crop insurance. Okay, just to provide some basic resources that the Ag Law Center provides for those of you that may not be as familiar with us, or as a refresher for those of you that are, I would encourage you to check out our website, which is if you just type in aglaw.psu.edu, you will have access to all of our resources. On our website, you can see the menu bar at the top to direct you to different aspects of our website. You can see on the right panel we have links to our social media. This particular page that you're seeing on the screen now kind of shows you our Agricultural Law Weekly Review, which is a weekly product that helps you stay up to date on current legal developments as those developments are taking place. We also have virtual resource rooms that take a particular topic and give you a variety of resources on that topic. Now, this is showing the Pennsylvania Right to Farm Act, which I'm going to talk about in more detail here in a few minutes. We also have agricultural law issue trackers, which again take a particular topic, but these trackers provide more of a timeline. So you can look at a topic and get a timeline of relevant legal developments in that particular area. We have podcasts that are available. If you choose to get your information through that forum, I encourage you to check out those podcasts. Are available on all of the main platforms. And also want to mention that that the center operates the Pennsylvania Agricultural Mediation Program. So if you or you have a client that you think would benefit from that, please let us know. Okay, so some basic information about the webinar. It is being recorded. If you have questions, we would ask that you use the Q&A feature for those questions. This program has been approved for 1 Pennsylvania CLE credit. So if you are a Pennsylvania attorney looking to get a CLE credit, the link will be posted in the chat, or perhaps already has been posted in the chat. And in order for us to fulfill our responsibility of verifying your attendance, we will provide a code word. And so at some point within the next hour, we'll provide the code word, and you will put that into into your CLE form. And I think we've clarified that form, so it should be a little bit more clear as to where you're supposed to put that code word in the form. Okay. So with that, we'll move on to the topic for today: understanding the basics of statutory protection of agricultural operations. I just see a poll popped up, so we'll have, I think, a poll at the beginning and a poll at the end that we would ask you to fill out. I just X'd it off of my screen. Hopefully, I did not close it for all of you. Hopefully, it's still, I just got it off of my screen and not yours. But that helps us to get a little more information about the audience. Okay, so the program today, I'm going to be talking for the first about 25 minutes. I'm going to focus on the Ag Area Security Law and the Right to Farm Act, Pennsylvania Right to Farm Act. And then Brooke Doerr is going to talk about ACRE and about Clean and Green. Okay, so starting off with the Ag Area Security Law, I think it's helpful to look at the policy where there are policy statements for these statutes. And for the Ag Area Security Law, which is essentially Pennsylvania's Ag District statute, the statute that, among other things, provides for the creation of areas that receive, within which agricultural operations receive certain protections. But the policy, and I've highlighted a couple words on your screen, but the policy that you can see is to conserve and protect and to encourage the development of and improvement of its agricultural lands for the production of food and other agricultural products. So it's focused on what is taking place on those lands, but also is providing that these agricultural lands are providing other benefits by acting as open space. So, I think just important to recognize that there really are those two purposes, that we want ag land because we need the agricultural products, but there also are some benefits of having that ag land as open space as well. Now, the Ag Area Security Law provides 3 protections. And as I mentioned, this is Pennsylvania's Ag District statute, where we establish a way to create these ag districts, which in Pennsylvania are called agricultural security areas. And when a farm or when land is enrolled in an ag security area, that land or that landowner or that farm operation is entitled to 3 basic protections. There's a limitation on local regulations, a limitation on the power of eminent domain, and eligibility to participate in Pennsylvania's Purchase of Ag Conservation Easement program. So I'm going to talk a little bit about each of those 3 benefits that are provided to landowners in an ag security area. Okay, so first, the limitation on local regulations. Now, those of you that are more familiar with this topic may be thinking, well, the limitation on local regulations really is what ACRE is all about, and Brooke is going to talk about ACRE. But the Ag Area Security Law also provides for that benefit, or for a benefit in this area, for farms that are in an ag security area. there's overlap, but there are some differences as well with the limits on local regulations. So in the Ag Area Security Law, municipality is not permitted to enact laws that would unreasonably restrict farm structures or practices within an ag security area. Now, I think the one thing that stands out to me there is the structures, because when Brooke talks about ACRE, he's going to talk about normal agricultural operations, which I would see as the practices, but not so much as the structures. So I think it's important to recognize that, when you have a municipal ordinance that you think is problematic to a farm, certainly you want to look at ACRE, but you also should take a look at the Ag Area Security Law if that farm is in an ag security area, because perhaps there is some protection available for your client. Also, the municipality has to exclude normal farming operations from within the definition of public nuisance. Now, this is an area that really is squarely addressed by the Right to Farm Act. But again, take a look at this. If you have a case where there's a potential nuisance or an ordinance that is addressing an ordinance. Now, the municipality is permitted to act for the benefit of public health and safety. So this is not a complete prohibition on municipalities acting. So I mean, this could be a pretty broad exception to allow municipalities to act for public health and safety. Okay, so that's the first benefit that is provided to farms within ag security areas. The second benefit is a limitation on the power of eminent domain. Now, again, this is not a complete prohibition on the use of eminent domain, but it provides essentially an extra hurdle. So if land is in an ag security area, if the government entity is going to use eminent domain, they're going to have to go through an extra process to utilize that power, and they have to go through this what's called ALCAB, or the Agricultural Lands Condemnation Approval Board. And ALCAB has to approve the use of eminent domain, and ALCAB will only approve the use of eminent domain if there is no reasonable and prudent alternative. So, those of you that have experience with eminent domain know that this is definitely a higher standard than what is normally required for the use of eminent domain. So, if there's a power line that's being proposed to go across land that's enrolled in an ag security area, then the government or the entity that is seeking to use eminent domain is going to have to show that there's no reasonable and prudent alternative in order to utilize eminent domain on that land. Okay, so that's the second benefit. And then the third benefit is that landowners within an ag security area can participate in Pennsylvania's purchase of ag conservation easement land, where they essentially sell their development rights to the government and in exchange for granting a perpetual easement on that property. Now, these so-called purchase of ag conservation easement programs, or sometimes referred to as PACE programs, these are present in a number of states. I have a couple maps that I'm going to show you here in the next slides that kind of show where they are, what states have these programs. But these are programs where the government provides money, and it might be the state, maybe the local government, but there's funding that's provided and is paid to farmers in exchange for the farmer essentially selling the development rights. And then there's a deed restriction that's imposed on that land that limits non-ag uses, or limits the conversion of that farmland. So where are these programs located? You can see about half of the states have a program. You look at kind of the geographic prevalence of them, very much in the Northeast, the Mid-Atlantic, region is, you can see every state, even some of those states that really aren't viewed as being strong agricultural states have those programs. As you get more out into the Midwest, programs aren't so prevalent there. Now, what about, what are the leading states? And on this slide, I'm showing you leading states based on acreage. The next slide I'm going to show you is leading states based on the number of farms that have been preserved. But you'll see Pennsylvania at the top of both of these lists. And when you look at the top 5, it's basically neighbors of Pennsylvania. So being located here in Pennsylvania, this is really the nationally, this is really where most of this, or maybe not most, but the highest level of activity relating to these ag conservation easements that are purchased by the government. And you can see that Pennsylvania and Maryland really strongly dominate in terms of the amount of acreage. And then when you look at the number of farms, again, Pennsylvania and Maryland are the two leading states in those in the number of easements. Okay, now looking, kind of drilling down and looking at Pennsylvania, looking at the percentage of farmland that is enrolled in those programs. I mean, no surprises here that you see kind of that's the southeastern, the south central portions of the state are those counties that have the highest level of enrollment in those programs. I mean, a few counties kind of scattered throughout the state that also have larger levels of enrollment, but just kind of reflects what you would think, knowing about Pennsylvania geography and Pennsylvania agriculture. Okay, so what's the process for establishing an ag security area? It's initiated by landowners. They submit a proposal to the local government unit. It goes through the Planning Commission, the Ag Security Area Advisory Committee. They make a recommendation. The municipality holds a public hearing, and then a decision is made. Now, I think one important thing to recognize in adding land to an ag security area is, once an ag security area is created for a township, additional land can be added to that. And that land does not need to be contiguous with other land that is enrolled in an ag security area. So I think sometimes people have a perception that this is one big mass of land, contiguous piece of land owned by multiple owners that is part of an ag security area, when really you can have scattered parcels within a township that are all part of its ag security area. And in determining whether particular land will be enrolled, these are the criteria. The municipality is looking at whether the soils are conducive, I guess a typo on my screen there, but whether soils are conducive to agriculture, whether the ag security area is compatible with the comprehensive plan, whether the land is viable ag land, and then look at other factors to kind of determine whether this is land that is particularly suitable for agriculture and should be protected as such. Now, on this topic of the criteria, I think there's one case that I would encourage you to look at, the 41 Valley Associates. And in this case, the particular use of the land was as a mushroom substrate a mushroom compost facility. And the landowners wanted to add that land to the ag security area. And the township looked at that particular use and said it doesn't meet the criteria. The Commonwealth Court overruled that and determined that you have to look at, I'm just going to scoot back to these criteria, that you have to look at agriculture broadly. And is this land suitable for agriculture, rather than looking at the particular agricultural use? So, certainly using land for mushroom substrate or mushroom compost is different than using it to graze sheep, but in looking at whether land is going to be enrolled in ag security area, you have to look at it in regard to its use as agriculture or its prospective use as agriculture moving forward. Okay, moving on to right to farm laws. I mean, right to farm laws are in all 50 states. Provisions vary from state to state, but generally that nuisance lawsuit protection is at the core. In looking at Pennsylvania's Right to Farm Act, it was enacted in 1982 and then amended, and this amendment is significant, in 1998 to address the expansion or alteration of ag operations. And I'll talk more about that here in just a minute. Again, looking at the policy, you'll see this first bullet is almost exactly the same as with the ag area security law. Then the second bullet is focused specifically on nuisance lawsuits. But the right to farm law in Pennsylvania is broader than just nuisance lawsuits. And there really are three protections again. The first is requiring that municipalities exclude normal ag operations from the definition of a public nuisance. The second is limiting nuisance actions against ag operations. And then the third is about direct sales. Now, this concept of a normal ag operation is it's a critical definition for right to farm as well as ACRE. And just to look at that definition, you'll see it's fairly broad, but not all encompassing. And so you look at activities, practices, equipment, and procedures in the production, harvesting, and preparation for market. Now, the one thing that is kind of missing from that chain is the actual marketing. So, while this statute is protecting producing, harvesting, and preparing for market, it isn't protecting the marketing itself. There is a size limitation on farms that they need to be at least 10 acres or have a projected annual gross income of at least $10,000. Okay, and with regard to the protection against nuisance lawsuits, a neighbor can't file a suit against the farm if the condition that they're complaining of has been, if that farm has been operating for at least 1 year, and the conditions that they're complaining of have existed for that 1 year, and those conditions are a normal ag operation. So basically, the neighbor has a 1 year time period to file a nuisance suit. If they don't file within that 1 year, they're precluded by the right to farm law. Now, this 1 year time period was amended in 1998 when the General Assembly addressed the expansion or alteration. So, put yourself in the position of a farm that's thinking about expanding. You're going to expend, hundreds of thousands of dollars or more to build a new facility. Do you want to do so if you have the uncertainty of potentially your neighbor having 1 year to file a nuisance lawsuit because they object to the smell, or they object to some other aspect of your farm? So to address that issue, the General Assembly amended the right to farm law to remove that 1 year time period if the expansion or alteration has been addressed in a nutrient management plan. So if a farm files a nutrient management plan, addresses their new operation, the 1 year time period is eliminated. And the neighbor now cannot file a nuisance lawsuit on day one. They have that, taken away. They're not able to file the nuisance. So that gives the farm much greater protection, or removes that uncertainty. Okay, now the third protection that was listed for right to farm law is this limitation on a municipality's ability to restrict direct commercial sales. And so if the sales are taking place on property owned or operated by the landowner who produces at least 50% of the ag commodities that are being sold, the municipality can't restrict those direct sales. Now, this language raises some questions. Do the sales have to take place where the crops or where the products are produced? It just says on land owned or operated by the landowner. The second bullet says produces at least 50% of the ag commodities. How is that 50% measured? Is it by the number of products? Is it by the value? We don't have any answer to that, but the statute just states produces at least 50% of the commodities sold. Okay, there are exceptions for the right to farm. You can see if, again, if there's a direct adverse effect on public health and safety, if the ordinance is in violation of federal, state, or local statute or regulation, if it's polluting, the right to farm is not going to provide protection. There's one case that I think is helpful because it's a very basic case, and it describes, again, the very basic application of the right to farm law. There's other case law. If you go to our virtual resource room on our website, you can look at those other cases. But in Horn v. Halliday, we had a poultry house that was constructed. We have a decomposition building that was constructed, and then there was a nuisance lawsuit. And if you look at the dates here, you can see, well, first of all, this was prior to the amendment in 1998 that dealt with expansion or alteration, but you'll see that there's more than a 1-year time period between either the construction of the poultry house or the decomposition building, that the neighbors waited more than a year to file the nuisance lawsuit. Then they alleged that the property had been devalued because of odor, noise, and flies. Well, ultimately, the court dismissed the case because it hadn't been filed within that 1-year time period. There were some other issues addressed by that opinion, but I think that, at a very basic level, it was a fairly simple application. They waited more than a year. The right to farm law applied. Now, with the 1998 amendment dealing with expansion and alteration, if the farm had filed a nutrient management plan, then we don't even have to look at that 1-year time period. The filing or the preparation and filing of the nutrient management plan would provide for the dismissal. Now, I think a very important practice pointer here is that your client may not be required to file a nutrient management plan, but it may be advantageous in order to get this nuisance protection. So that's something to think about. Even if you're not required, you want to consider it because of the certainty that you're going to get through the right to farm law. I want to just talk very quickly about some constitutional issues because there was a case in Iowa, which I have in the next slide. This goes back 1998, but this Iowa case struck down, giving you the code word there. This Iowa case struck down Iowa's right to farm law as being unconstitutional because the statute provided for an absolute prohibition on filing suit against farm operations, and kind of post that case, the analysis of their different states' statutes kind of focused on whether they were absolutely prohibiting filing suit or whether they were limiting the filing of suit. Pennsylvania's statute is really a hybrid because it generally provides for a limited prohibition in that 1-year time period, unless there's the filing of the nutrient management plan where it is an absolute prohibition. Now, there is absolutely no case law looking at the constitutionality of Pennsylvania's right to farm law, but I'm just kind of putting that out there, as an issue to potentially be aware of.
All right, so good afternoon, everyone. Beautiful day. Thanks for committing to this on such a nice day. Again, we're going to be up here at the 40,000-foot view to some degree of these issues at a somewhat basic level. And hopefully I'm not talking under people's level of understanding too far. I know we have some people who are familiar with these issues here, and some of these issues then we'll delve into deeper subsequent sessions. I'm going to talk about essentially two things. I'm going to talk about ACRE, and then I'm going to talk about clean and green. Now, in the grand scheme of things, in terms of the statutory protections to ag operations and sort of the viability of ag as an expression of Pennsylvania policy, you might want to consider, and it generally is sort of put forth, that clean and green might be the most simple and elemental of the statutes, basically creating a property tax break for those who are putting their land to ag use. And there's some other uses that also qualify you for that tax break, basically leaving their land undeveloped. So that's sometimes viewed as the most simple and primary protective statute. But with the way we're doing things, we thought it flowed a little better maybe to have it at the end, because of the way that these beginning issues kind of relate to each other. They sort of flow through ag area security law, and then right to farm, and then ACRE. So little out of order from the way some people would maybe present this, but we're going to talk about ACRE first here, which flows nicely directly out of the right to farm law protections, because it really was a statutory remedy that came right from the perceived inadequacies of the right to farm law and going that extra step. And Pennsylvania is quite unique in that, as Ross said, you have 50 states with right to farm laws in various permutations, and some of which have not been very successful, by the way. Those of you that are aware of the North Carolina Smithfield hog operation nuisance lawsuits that were what some people might call runaway verdicts in North Carolina, they had a right to farm law. It just didn't do what it was supposed to do, or what people thought it was going to do. Or I should say, it was enacted midway through, but even the enacted version, the first enacted version, did not do what they thought it should do. And so they're not all the same. But my point is, Pennsylvania has gone an entire other step beyond that to the ACRE statute. So it's really perceived as quite the gold standard, maybe you might say, with regard to what would come after the right to a basic right to farm law. And then we'll talk about clean and green here. So let's go. Okay. ACRE was enacted in 2005, and many of you might know the history, which is there was a desire to try to, particularly related to odor complaints and from various livestock operations, that there was a desire to try to craft a process whereby there could be some type of amelioration or ability to lessen the tension between residential and agricultural uses where they butt up against each other. And again, odor complaints were a lot of the driving force behind that. And that's why it's got such a funny name. Agriculture, communities, and rural environment is kind of a mashup of the stakeholders or the interest groups, or the where the tension was occurring was between these different entities, agriculture, and rural communities and the rural environment. So that's how it got its name. And it gets confusing, of course, because there is actually an acronym, ACRE, same ACRE, at the federal level as part of a USDA program. But we'll leave that aside. It is prone to create a little bit of confusion. But in any event, some people still call this Act 38, and as attorneys, we probably all are uniform in the fact that those kind of ways of referring to statutes drive us crazy. That was yours, Act 38 of 2005, and there's probably been as many Act 38 since as well. We've gotten to Act 38, I think, in every legislative term, and those are 2-year terms. So we've had a lot of Act 38s since. So in any event, people say Act 38, that's what they're talking about. Now, the purpose was to try to create a process whereby local municipal ordinances that regulated this new category that was defined in this law as normal ag operation, I should say, defined in the right to farm law as normal ag operations, were a process for reviewing ordinances that might be restricting normal ag operations. And this was coupled with an odor management portion or amendment to the Nutrient Management Act, which created these odor management or supplementation, shall we say, to the Nutrient Management Act, which created odor management requirements and an odor management plan concept. And that was sort of the corollary that went along with this when it went through the legislature. I was in private practice at that time, so I wasn't as quite clued into all of that history as some of you may be. And okay, so it created the concept, it borrowed the concept of the normal ag operation from the right to farm law and said, okay, what would be the kinds of things that would be in some way unreasonably restricting a normal ag operation, and beyond just the nuisance suits, which the right to farm law addressed. And again, the easy way to remember the nuisance suit situation is that the ag area security law dealt with public nuisances, in other words, nuisance by municipal ordinance. And then the right to farm law dealt with protections with regard to private nuisance actions brought by private citizens. So they do have two separate ways of dealing, there are two separate purposes of the nuisance provisions in those two laws, but that was seen as inadequate, and we'll get to that in a minute. So then they created this concept of the unauthorized local ordinance. And so that's the term of art. So you have a number of term of arts created here, terms of art created here. And essentially the law prohibits or limits a normal ag operation, an unauthorized local ordinance prohibits or limits a normal ag operation unless the local government unit has authority under state law to adopt the ordinance, some type of specific authority that's already been through the legislature, and that it's otherwise not prohibited or preempted by some other act of the state legislature. And then there's this other little tack on about restricting ownership structures. We'll talk about that in a minute. So two purposes there. I don't know the history of the restricting ownership structure. I'd love to hear anybody's sort of war stories on that. Okay, so again, what we just went through, Right to Farm Act had its limits. The right to farm only says that a normal ag operation cannot be subject of a nuisance claim. That's a private nuisance claim under the circumstances that Ross described. Ag area security law deals with if you're in an ag security area, you are getting protections from nuisance by public ordinance. It only created a defense to nuisance claims. In other words, you had to get sued first in order to even invoke it. So it wasn't all that useful. And so, of course, it made the farmer have to bear the costs of being sued, and then they were allowed to assert this, this concept in the right to farm law, and that was seen as, not particularly helpful. And there needed to be a way to turn this into a sword, so to speak. Use it offensively. And I don't mean that in a negative way, just that it was, we all sort of learned the concept in law school of offensive use of collateral estoppel. And, that it's the same concept here is turning a protective measure into, an action that can be pursued before someone is sued in an offensive way. Now, and again, here's my analogy to the sword and shield concept here. So it created this sort of offensive enforcement mechanism to fend off, let's just say, for lack of a better way to describe it, something that was a local regulation that was perceived as infringing on normal ag operations. And again, same bill as the odor management provisions that we live with today. And and it's kind of amazing that we are pushing 20 years since ACRE was enacted. Important to keep in mind that while a facial reading of the statute would almost lead you to believe that it addresses municipal regulation of normal ag operations and gives you this offensive, a way to use, some state protections on an as-written basis. In other words, that you could only attack the ordinance as written. It has, in practice and by necessity, it also can attack the way in which a ordinance is being applied. So it's not just offensively able to be used against an ordinance as written, but also as applied. So sometimes you'll have a circumstance where a client has a problem with a local ordinance that is really causing them an inability to do something that would be considered within the ambit of a normal ag operation. And it's not necessarily the ordinance on its face. It's the ordinance as it's being applied to the particular facts in this instance. So that's an important concept to understand, because that's not really written in the statute itself. But you're still, if you are using the ACRE legal theories there and attempting to invoke them, you can invoke them in an as applied context in addition to an as written context with regard to what that ordinance's net result is. Okay, so the basic rule under ACRE, simple as it can be, a local government unit. That means even beyond townships, this could be county. However, we haven't seen a whole lot of that go on. It's always been, up to this point, it's been, concentrating on a township level and, borough level, that sort of thing, but it's not limited to that. Shall not adopt or enforce an unauthorized local ordinance. So there's all your terms of art. The unauthorized local ordinance is, elemental to the basic concept. So you have these two terms of art. And again, whether in fact a local ordinance is unauthorized is essentially, in using the litigation concepts, it is the ultimate issue in a case or in a claim. The Attorney General's involvement, as we'll see in a minute, is all essentially them expressing their opinion on the unauthorized local ordinance. Is it one, or is this one, or is it not one? But that's just like negligence in a slip and fall case, in the sense that in the end, it's the fact finder, which in the way this is set up, it's the Commonwealth Court. Sorry, I'm jumping ahead a little bit. That would be making the ultimate determination, and everyone else is simply expressing their advocacy that in fact this should be considered and will be considered unauthorized local ordinance by a Commonwealth Court after trial, should it go that far. Okay, now, here, the basic concept: any ordinance enacted by a local government unit that prohibits or limits a normal ag operation, unless the government unit has authority under state law to adopt the ordinance, and it's not prohibited nor preempted by state law from adopting the ordinance. A little complicated, but all those things need to be said in order to set up the proper analysis. The definition now also includes this oddball little thing about unauthorized local ordinances can be things which restrict or limit the ownership structure of a normal ag operation. Presumably, this was intended to mean corporate farms, or that word or that terminology that some people use. And you see this in other states sometimes more than in Pennsylvania. I don't think and again, I'd love to hear some war stories on the genesis of this, because I don't think we've, of course, it may be because the act is here, but we haven't seen much in the way of problems with local regulation attempting to somehow outlaw so-called corporate farms, whatever that means. Now, will this someday be used to deal with foreign or out-of-state ownership? If that becomes a sort of a fad of the day to be enacting local government ordinances in that regard, sort of an unanswered question here. We do have state laws in many parts of the country that deal with foreign ownership of ag lands. Pennsylvania has such things on the books also, not enforced in any way, shape, or form in Pennsylvania. And they go all the way back to the Civil War, which, the beginnings of these were, in fact, to prevent those who participated in the Confederacy from owning land in particular states after the Civil War was over. But now this concept has morphed into a foreign ownership issue. And it's a very active and hot issue in many states, not here, but in many other states. Okay, what's a normal ag operation? Well, again, we're incorporating from the right to farm law, and got a little note there with a link, and so it's exactly what you'd expect. And as Ross was saying, you already went over it. Does not include marketing. So when people start talking about acre cases, keep in mind that does not include things that are restricting their ability to sell products from the farm, and invite the public onto the farm to do business with the farmer on the farm. Those marketing and retail sales are not within the ambit of a normal ag operation that might receive protection under the ACRE statute. Very important concept, because the entire industry to some degree falls into the trap of thinking that it does. And we get tons of calls. And then has to be at least 10 acres, or if you're less than 10 acres, you have to have a annual gross income of at least $10,000 from the agricultural activities. There's a little coda in the definition about that they felt necessary about it, that this would include not just historically accepted practices, but other new activities and practices and equipment that are being utilized in connection with agricultural activities. There's the case that really illustrated this one right out of the box was the deer cannon cases, where people were using various percussive and mild explosive or just noise related equipment in order to scare deer from tree farms, fruit production facilities, crop farms, etc. Also, again, note that there's an absence of marketing and retail sales in that definition. Now, how's it work? The producer submits a written request to the Attorney General's office for review of the ordinance, and then the Attorney General has 120 days to review and determine whether to accept the case. If the Attorney General accepts the case, the municipality is given an opportunity to discuss the ordinance before the Attorney General might file suit. And those negotiations have taken care of a very, very large amount of the cases that have been referred to the Attorney General thus far. And this process between the Attorney General's office and townships, when they receive these letters from the Attorney General's office that a complaint has been filed about a particular local ordinance, either as written or as applied, there's a familiarity now between township solicitors and this practice and procedure, and those negotiations, whether they're warmly engaged in by municipalities, they have been successful. And then ultimately, if not successful, and the Attorney General is of the opinion that there has not been a sufficient resolution of the issue, then they file suit in the Commonwealth Court, take it to trial. It's a bench trial. And we have had no bench trials under ACRE since its enactment, where the ultimate issue was requested to be decided by the fact finder, meaning the Commonwealth Court, either single judge or panel of judges. If somebody's got some info on that makes me wrong, that there was one, I might have missed it. Everything has been disposed of on motions, dispositive motions up to this point in time, either by settlement or dispositive motions. No trials yet, and we're approaching 20 years. So that's a successful statute, honestly. Okay, this is a great improvement because the costs are borne by the Attorney General's office, not the landowner. So the landowner gets an offensive use of a of a protective right granted to them by statute, and it's actually being essentially asserted, or the pursuit of it is being handled by the state government. So that is an expression of policy right there. Wait a minute, let me go back. There we go. There's also a private right of action under ACRE that has not been utilized much at all. It's been utilized a little bit in sort of anecdotal here and there. I've heard of instances, deer canning case, for example, but very, very, very underutilized. But it's there, and I'm kind of shocked that it's so underutilized. There is a permissive award. In other words, it's not mandatory, but the court may order at the end of a trial or upon motion, even upon disposition of a dispositive motion, an award of attorney's fees and costs. That would be an award to the plaintiff if the defendant municipality or local government unit negligently disregarded the fact that what they were doing was violating the ACRE statute. It was the unauthorized ordinance, should have been recognized by them, and they negligently disregarded that concept. Or for the defendant, if a township, if in fact it is determined that the lawsuit was in fact frivolous and without substantial justification, there could be an award to the defendant government unit. The advantage is that the litigation Commonwealth Court establishes the statewide precedent. And there's an annual report, by the way, in the statute required. The 2020 annual report is the last one that came out. They don't put them, for whatever reason, they are not on the Attorney General's website. Wish they were. We have them on our website at the Ag Law Center. If you ever want to see them, that's a link to the 2020 report. Very informative. I mean, the list, the numbers, the data on the number of cases, very, very interesting read. Okay, now there's a couple things. This is the pamphlets that the Attorney General puts out. Here up in the upper right-hand corner is the Attorney General's link to their website. Their website is vastly improved over what it used to be like, and I'll show you a little screenshot of it in a minute. Here's their pamphlet that they distribute now with the current Attorney General's name on it here. And there are two lawyers at the Attorney General's office who work on cases actively now. And the second lawyer, who was more recently brought into the fold, so to speak, her name is escaping me. But then the first lawyer is Rob Willig, who's out in the Pittsburgh office. And then the second attorney is a woman who is in the Harrisburg office. And I should have looked that one up. Her name is escaping me right now. But there is more staffing than there had been in previous years, for what that's worth. Okay, this is what the website looks like today. It's very interesting. There is a table, and this is just the very top of it. There is a table that you can go through, and hopefully this isn't too small for you to see, but I'm going to move my cursor over here. There is date that it's received, who is the government entity involved, basically what's the complaint in some very, very general terms. Then there's a copy of the ordinance that is being challenged, either written or as applied. And you can look at that. Sometimes they're incomplete because it's whatever the complainant may have sent in, but it gives you a general, gist that you can start to begin to understand. The complaint letter is there to be looked at and downloaded. If it's far enough along where the township has responded, their response is there. There's a status column, and there's also a disposition column that tells you what exactly happened. Here, accepted and settled. Accepted means the Attorney General's office took the case and said, we agree, we think there is an authorized local ordinance, and it's proceeding. Accepted and settled mean they accepted it, they proceeded ahead, and then it ultimately settled. And so these letters are usually either the conclusion letter or the letter that tells the township that the Attorney General's office has decided to pursue the case. They do the negotiations before and after the acceptance letters sometimes. Before the acceptance letters is mostly, give us more information on this, give us more information on that. And those kind of letters will appear in here also. Township response might get updated depending on where they are in the whole process. Okay, so there are several pages and pages of these. They only go back to a certain point, and I forget the time parameters, but this is really worth a look because this really gets you going. And if you have a problem with a client, in a particular township, this can provide you with other arguments that were made in other cases similar to yours. It can tell you whether this township has ever been involved before and how they responded. There's lots of great info that can be gleaned from this. The Attorney General's office's letters, when they accept the case, give you great ammunition for understanding how things have been historically viewed. So this is a wonderful resource. This is just great. And the annual report was all right. This is much, much better. This is a new, within the last, I don't know, 7, 8 years that this was put up, maybe even shorter than that. Okay, now, so that's ACRE. ACRE is not a preemption statute per se, although it has that component in there where preemption is part of their analysis, as we talked about previously, in determining if there's an unauthorized local ordinance. If preemption applies, then that's obviously going to come into play.
Hey, Brooke,
What I wanted to show you here,
jump in and give you a time check. We've got about 4 minutes before we need to wrap it up.
I will skip over. I'll just tell you this. If you're ever in a situation where you have what you think may be a sort of bordering on an ACRE complaint, where you think that someone may be being regulated in a way that is inconsistent with or in excess of some state law requirements that apply to that same field, et cetera, you're starting to border into, sometimes with ACRE cases, you start to border into what are preemption concepts. There's a great section in the MPC that actually is not an express preemption section, but it's darn close in the way that it's worded. And here I've started here, so I will just skip ahead to clean and green. Here's a very interesting case about some preemption issues with regard to the Nutrient Management Act, which basically illustrates that this was a Supreme Court case. It illustrates to you that the issues of preemption are not that easy, and there's much more out there than most of us think. It's not black and white. And there are a lot of gray areas where you might get mileage out of some arguments that certain areas are going to be considered unauthorized local ordinances, depending on what already exists in the state at the state level with regard to regulating the same area. Okay, clean and green. Clean and green is, of course, a preferential tax assessment program whereby leaving your land undeveloped in one of 3 categories produces for you a reduced tax assessment. And 59 of the 67 counties have this program in place. The counties that do not have decided that it is an optional thing for the county assessor to either adopt a clean and green program or to not. And of course, that goes back to your county authorities, whatever they may be under the form of county government that you have. So there's links to the statute, the regulations. Here's the PDA webpage. It's a process whereby the income approach to land appraisal is used to actually get a current use value of land rather than its highest or best use, which is the basis of all other property tax assessment in the state of Pennsylvania. So now here are the 3 categories: agricultural use, agricultural reserve, and forest reserve. They have various categories or various criteria, I should say. The most important part is that there's a minimum lot size of 10 acres for all of them. And although ag reserve, I believe, can use that borrowed thing about less than 10 acres if you have this anticipated income. Maybe ag use has that too. It's been a bit since I've looked at that. Now, the key to understand is that we will do a much deeper dive on clean and green because there is so much to it. The big issue with clean and green is that essentially if you accept the reduced property tax assessment, then you are essentially entering into a covenant with your county assessor's office that you will not change the use of that land. And if you do, and that lasts for as long as your land is enrolled, and you can't unenroll your land voluntarily once it's enrolled. And if you change the use, and sometimes people decide to change the use purposely and take the hit, they will get a rollback tax assessment, which means they're going to have to pay back the last 7 years worth of tax savings that they realized by being in the program. So it's kind of a 7-year backwards look where you have to regurgitate, essentially, or, pay back that tax benefit that you got for the last 7 years if you change the use. Lots more complicated rules to be applied in Clean and Green. Unfortunately, I kind of ran out of time here. There are so many exceptions in Clean and Green that the exceptions sometimes feel like they swallow the rules. One of the most important ones is the concept of the rural enterprise, which is essentially a business that is occurring at the property that will not violate this idea that you're going to leave it in ag use only, because it has a certain connection to the rural, and they say, the concept is a rural enterprise incidental to the operational unit. So the harness, the tack shop or the harness, shop at the Amishman's farm, those things that arise from the ag use that's being done there. Okay, I will stop because obviously we're out of time. Sorry about that. We didn't get to go through, but we will definitely be tackling Clean and Green in the future in this series.
So thank you everyone for attending today's program. Our next program, we will be focused on agricultural cooperatives. If you have any feedback on programs you would like to see, as Brooke mentioned, I think Clean and Green is a topic that we will devote at a future session. So please give us that feedback if you have other topics. So thank you again for attending, and we look forward to seeing you in the future.